My name is Celeste Warwick. I'm 33 years old. And the night of my Uncle Raymond's retirement banquet was when I finally understood that the people who claim to act in your interest are sometimes the ones you most need a lawyer for. My father said it clearly, in front of 64 people at Table 7 of the Grandview Ballroom. You were in no condition to manage property. We did you a favor. I had just asked him, in a voice I kept level, why the house on Alderton Street no longer had my name on it. That was his answer. I did not stand up. I did not raise my voice. I set my napkin on the table, folded it once along the crease, and placed both hands flat on the cloth in front of me. What none of them knew, not my father, not my mother, not my Aunt Patricia watching from Table 3, was that a title officer named Ruth Callahan had been sitting with that deed for 22 days. And she had found something in it that my parents had not anticipated when they signed. I need to go back to the house first, because the house is where everything starts. My grandmother, Eleanor Warwick, bought the property on Alderton Street in 1971 for $34,000, which in that neighborhood at that time was everything she had. She was a bookkeeper for a regional freight company for 31 years. She did not spend carelessly. She did not borrow unless she had a plan to repay. She kept a ledger by hand until she was 81, and the last entry in it, made 4 months before she died, was a notation that the property taxes on Alderton Street had been paid through the following calendar year. She left the house to me, not to my parents, not to be divided among the family. To me, specifically, in a trust she had established with an estate attorney named Howard Greer 11 years before she died, amended twice, once when my Aunt Patricia's marriage ended, and once when my father's business had a difficult 3 years that she did not discuss openly, but had clearly assessed with precision. The trust named me as sole beneficiary of the Alderton Street property. It named my parents as successor trustees for the limited purpose of managing the property during any period in which I was medically incapacitated and unable to manage it myself. That language, medically incapacitated, was the door my parents decided to walk through. I was diagnosed 14 months before Uncle Raymond's retirement banquet. The specific diagnosis was a form of non-Hodgkin lymphoma, intermediate grade, which my oncologist Dr. Priya Anand at Westfield Cancer Center described as serious, treatable, and requiring an aggressive initial protocol. I started chemotherapy 8 weeks after diagnosis. The first 2 rounds were difficult in ways I will not catalog here because this story is not about the illness. It is about what my parents did during it. What I will say is that during the first 4 months of treatment, I was genuinely not functioning at full capacity. I had a port in my chest. I was at the clinic 3 days a week. There were 2 weeks in the second round where getting from my bed to the kitchen required planning. My parents were present during this period. They drove me to appointments. They brought food. My mother stayed at my apartment for 11 days during the worst stretch of round 2, sleeping on the pull-out in the living room, making soup I could not always finish. I do not want to flatten this into a story where they were simply villains from the beginning because that is not accurate and it would not make sense of what came after. They were people who had watched their daughter become very sick, who had a structural access they had been given by a document they may not have read as carefully as they should have, and who made a decision that was wrong in almost every dimension, legally, ethically, practically, and then constructed a justification for it that they had apparently rehearsed well enough to deliver at a retirement banquet without visible hesitation. The structural reason for what they did was not complicated. My parents had been financially uncomfortable for a number of years. My father's landscaping business had contracted significantly after a commercial client ended a long-term contract in the same year that 2 of his equipment loans came due simultaneously. My mother had reduced her hours at the dental office where she worked as an office manager when her own health required 2 procedures that left her with limited stamina for several months. They were not destitute. They owned their home, had a vehicle, and maintained the ordinary surface of a functioning household. But they were stretched in the way that people stretched for years, sometimes make decisions they would not have made from a position of ease. The Alderton Street property, by the time my grandmother died, had appreciated to a value my parents were clearly aware of. My grandmother had not hidden the trust from them. She had told my father, when she established it, that she had made her decisions and they were final, and she trusted he understood her reasoning. He had said, according to my Aunt Patricia, who was present at that conversation, that he understood. What he had understood, apparently, was that the document existed. What he had not taken seriously enough was what it said. During the second month of my chemotherapy, when I was not tracking financial matters with the attention I normally applied to them, my parents contacted Howard Greer's office and were told that Mr. Greer had retired 2 years earlier and the file had been transferred to an associate named David Pell. They did not contact David Pell. Instead, my father contacted a different attorney, a real estate specialist named Conrad Marsh, whose office was in a strip mall 12 minutes from my parents' house, and presented him with a set of facts that included, apparently, a characterization of my medical condition as constituting incapacitation under the trust's language. Conrad Marsh prepared a transfer document. My parents signed it. The property was listed and sold in 6 weeks to a young couple named the Hendersons for $387,000. After fees, my parents received $341,200, which they divided between themselves. I did not know any of this while it was happening. I found out on a Tuesday morning in the 4th month of treatment when a letter arrived at my apartment, forwarded from the Alden Street address, which should have been the first signal to whoever forwarded it that something was wrong, from a title company called Meridian Title Services. The letter was addressed to me. It referenced a property transfer at the Alden Street address and asked me to contact their office regarding a documentation question on the file. The woman I spoke with at Meridian Title was named Ruth Callahan. She had been a title officer for 19 years and had a way of stating facts without inflection that I recognized from my own professional training as a paralegal as the particular composure of someone who has found a problem and is being careful about how much she says before she has confirmed it fully. She told me that my name appeared on the original trust document as sole beneficiary, that the transfer had been executed under a trustee authority provision, and that she had a question about whether the triggering condition for that authority, specifically, whether I had been formally assessed as medically incapacitated by a licensed physician at the time the transfer was executed, had been properly documented. I asked her what documentation the transfer file contained on that point. She said, "That is the question, Ms. Warwick." I sat with that for a moment. Then I asked her to give me 48 hours before she took any further action on the file. She said she could do that. I called David Pell. David Pell was 39 years old, had taken over Howard Greer's estate files 2 years earlier when Mr. Greer retired to Arizona, and had apparently been waiting for a call like mine with the particular readiness of an attorney who has reviewed a file and formed a view. He had the trust documents. He had my grandmother's amendment history. He had a very clear understanding of what medically incapacitated meant in the context of that specific instrument, which included a requirement, written in by Howard Greer at my grandmother's explicit instruction, according to the file notes, that incapacity be formally certified by a treating physician and documented in writing before any trustee authority could be exercised over the Alden Street property. No such certification existed in the transfer file. Dr. Anand had never been contacted. She had never issued a certification. She had, in fact, no record of any request for such a document. David Pell said, in the careful way of an attorney choosing his words, "Ms. Warwick, I think you should let me review the complete transfer file before either of us says anything further about what this means. But I want you to know that what you've described, if it matches what I'm reading, is not a straightforward situation for the transferring parties." I said, "I understand." He said, "I'm going to contact Meridian Title today, and I'm going to contact you by end of week." I said, "Thank you." I put the phone down on my kitchen table. Through the window, the neighbor's dog was crossing the lawn in the unhurried way of a dog that has nowhere particular to be. I watched it until it disappeared behind the fence. Then I made a cup of tea I did not drink and went to lie down because I had a clinic appointment the following morning and I needed to be careful about my rest. I did not call my parents. I did not tell them what I had found. I had David Pell and Ruth Callahan and a trust document my grandmother had spent 11 years maintaining in exactly the right order, and I did not need to do anything else. Uncle Raymond's retirement banquet was 6 weeks later. Raymond Warwick had been a high school vice principal for 27 years, and his colleagues had organized a banquet at the Grandview Ballroom with the thoroughness of people who take institutional occasions seriously. There were assigned seats, a program booklet, a slideshow, and a catered dinner for which the chicken entree had a sauce that Raymond's wife, Carol, had personally approved after 2 tastings. I had been invited months before my diagnosis and had decided, after consulting Dr. Anand, that attending was within what I could manage at this stage of treatment. Round 4 had gone better than rounds 2 and 3. I was thin and tired but functional, and Raymond had been kind to me throughout the previous year in ways I wanted to acknowledge. My parents were at the banquet. We had not spoken about the property. They did not know that I had spoken with David Pell or Ruth Callahan. As far as they were aware, I had received no communication about the Alderton Street transfer, or if I had been too unwell to understand it. I was seated at table 7, between my cousin Diane and a retired teacher named Mr. Forsyth, who had mentored Raymond early in his career and who talked, through most of the appetizer course, about a fishing trip he had taken the previous summer to a lake in Manitoba. I listened to him with full attention. I ate the bread roll. I watched Raymond at the head table receiving congratulations from a succession of people who shook his hand with genuine warmth. My parents were at table 5. My mother caught my eye once during the salad course and gave a small wave, the kind that means everything is normal. I nodded. It was between the salad and the main course that I walked to table 5. I had not planned the timing. I had planned the question, one question, stated plainly, in a voice that would not carry to the neighboring tables if I positioned myself correctly. I crouched slightly beside my father's chair so that I was at his level and said, "Dad, I got a letter from Meridian Title about Alderton Street. I need to understand what happened to the property." My father's response was immediate. He did not lower his voice. He said, in a tone he apparently felt was authoritative, "You are in no condition to manage property. We did you a favor." My mother, beside him, set down her fork. The people at table 5, my Aunt Patricia, my cousin Marcus and his wife, 2 of Raymond's colleagues whose names I didn't know, had heard. The tables in the Grandview ballroom were not large. I did not respond to my father's statement. I stood up, returned to table 7, sat back down, set my napkin across my lap, and asked the passing waiter for a glass of water. Mr. Forsyth, who had paused mid-sentence about the Manitoba Lake when I stood up and returned to the table, waited a moment and then asked if I was all right. I said, "Yes. Thank you." He nodded and resumed the fishing story. I listened to the rest of it. What my father had not understood, sitting at table 5 with his authoritative tone, was that the room had already shifted before he spoke. My Aunt Patricia had known about the trust. She had been present at the conversation between my grandmother and my father 11 years earlier, the one where my grandmother said her decisions were final. She had not known about the transfer until I had called her, 3 days before the banquet, to ask her what she remembered about the trust's specific language. She had told me what she remembered. She had also told me, in the flat voice of someone who has formed a conclusion they are not pleased about, that she had wondered, in the months since my grandmother's death, whether the property situation was going to become a problem. She had not said anything to my parents about our call. At the banquet, after I returned to table 7, Patricia sat at table 5 for approximately 4 minutes. Then she stood up, walked to where Raymond was standing near the podium during the pre-dinner speeches, and said something to him quietly. Raymond's expression changed in a way that the people nearby noticed. He glanced at my father's table. Then he glanced at me. Then he nodded once and returned to the podium. Patricia walked to table 7 and sat down in the empty chair on my other side, the one that had been set for a colleague of Raymond's who had sent apologies at the last minute. She said, at a volume only I could hear, "Howard Greer built that trust very carefully. Your grandmother made sure of it." I said, "I know." She said, "David Pell is good." I looked him up. I said, "He is." She put her hand flat on the table beside mine, not touching, just present, and we sat there through the remainder of the evening. I ate the chicken, which had a good sauce. Raymond gave a speech that was warm and specific and made several people in the room laugh. My father, from table 5, did not come to table 7. My mother looked at her plate through most of the main course. That was how the room changed. Not loudly. Not with a scene that derailed Raymond's evening. My aunt walked from one table to another, and a retired vice principal looked at his brother with an expression that said he had understood something, and the evening continued exactly as it was supposed to. David Pell filed within 10 days of the banquet. The filing was a civil action in the probate division, on the grounds that the trustee authority exercised in the property transfer had not met the certification requirements specified in the trust instrument. The core of it was straightforward. The transfer was procedurally invalid because the condition required to trigger trustee authority had not been established by the required documentation. No physician had certified incapacity. No formal process had been followed. The transfer had been executed on the representation of the trustees themselves that the condition had been met, which, as David Pell explained to me in terms I could follow without difficulty given my background, was not how trust instruments work. Ruth Callahan's title company issued a formal hold on the property records and cooperated fully with the filing. She provided a written statement confirming the documentation gap she had identified and the date on which she had first contacted me. Dr. Anand provided a statement confirming that she had never been asked to assess or certify my capacity and that her clinical notes from the period in question documented active patient participation in treatment decisions, which was inconsistent with a finding of incapacitation. Conrad Marsh, the attorney my parents had used for the transfer, withdrew from the matter and did not contest the filing. The resolution took 7 months and produced, in the end, a court order requiring restitution of the net proceeds from the sale, $341,200, to my trust, along with the legal costs David Pell had documented. My parents did not have $341,200 liquid. What they had was their own home and a set of options that David Pell's filing had significantly narrowed. They retained a different attorney, a woman named Gloria Hines, and over 4 months of negotiated process arrived at an arrangement that involved a structured payment plan secured against their property. I did not attend any of the proceedings in person. David Pell represented the trust. I received updates by phone and by letter, and I continued my treatment, which by month 3 of the legal process had moved from the aggressive initial protocol to a maintenance phase that Dr. Anand described at my 6-month skin review as showing the response she had hoped for. The Hendersons, who had bought the house in good faith and were informed of the dispute early in the process, were fully protected by their title insurance and were not required to vacate or return the property. The restitution came from my parents, not from the sale. This was the correct outcome. The Hendersons had done nothing wrong. My parents paid the first installment of the structured restitution on a Thursday in November, 11 months after Uncle Raymond's banquet. David Pell called me to confirm. I thanked him. He said the file would remain open until the final payment was received, which he estimated at 3 years at the current schedule. I said, "That's fine. I have time. The matter of my parents and me is not resolved in any clean sense, and I want to be precise about that because I think imprecision on this point is where these stories most often go wrong." My mother called me 4 weeks after the filing. She did not apologize, not directly. She said that she had not understood the legal situation and that she had trusted my father's assessment of what was permissible. I listened to this. I said that I understood she had trusted him. I said that the trust document had been clear and that Howard Greer had written it specifically to prevent the kind of interpretation my father had applied. I said that I did not require an apology in this call, but that I did require that she understand what had actually happened, not the version that had been constructed for the banquet. She was quiet for a long time. Then she said, "I think I knew it wasn't right." I said, "Yes." We did not talk for another 6 weeks after that. When we resumed contact, it was in the careful, reduced way of two people who are navigating a diminished territory, which is its own kind of honesty. My father and I have not spoken directly since the banquet. His attorney communicated with David Pell. That is the current arrangement. I have no plan to change it before I am ready to, and I am not ready. Uncle Raymond called me in the spring, 8 months after the banquet, to ask how I was doing. He asked about my treatment first, and my legal situation second, which was the correct order of priorities, and which I noted. I told him I was in a stable phase. He said he was glad. He said that the evening of his banquet had not gone the way he expected, but that he had found out things that night he was glad to know. I said I was sorry his retirement dinner had become the occasion for it. He said, "Don't be. Your grandmother would have handled it exactly the same way." I thought about Eleanor Warwick's ledger, with its final entry on the property taxes, made 4 months before she died. I said, "She was thorough." Raymond said, "She was the most thorough person I ever knew." There is something I think about often, which is the gap between what a document says and what people believe a document means. My grandmother spent 11 years maintaining a trust that said, with precision, what would happen to the house on Alderton Street. She amended it twice when circumstances changed. She paid Howard Greer for his time and his specificity. She told my father, directly, that her decisions were final. She made an entry in her ledger about the property taxes 4 months before she died. She had done everything right. The document was correct. The language was clear. And still, 11 years after she established it, my parents looked at a provision that required a physician's certification and decided to proceed without one because they believed or had convinced themselves that the spirit of the provision was satisfied even if the letter was not. That the circumstances were close enough. That I was sick enough. That a reasonable person looking at it would agree. What they had forgotten or never fully understood was that documents do not operate on reasonable person assessments made by the parties with the most to gain. They operate on what they say. Ruth Callahan had been reading documents for 19 years. She read what the document said. The house is no longer mine in a physical sense. The Hendersons live there, and I have no interest in disturbing that. What my grandmother left me is in my account now where it belongs, and I am doing with it what I think she would have expected, carefully, specifically, with attention to the details. A document that says what it means is an act of care across time. My grandmother knew that. I know it now in a way I could not have known before 33, before the port in my chest, before the Tuesday morning letter with the Meridian title return address. What you build correctly and maintain correctly and leave in the right hands, it holds. Even when you are not there to defend it. Even when the people who were supposed to protect it decided they had a better use for it. It holds. There is a moment I keep returning to, and I want to ask you about it. It is not the moment at table 7 when my father said what he said. It is not the call from Ruth Callahan, or the conversation with David Pell, or the morning the court order came through. It is my Aunt Patricia, walking from table 5 to where Raymond stood near the podium, and saying something I still do not know the words of. I have never asked her what she said. She has never told me. But Raymond looked at my father's table and then at me, and he nodded once, and that nod, whatever it meant, whatever it contained, was the moment the room became something different than it had been before she walked across it. If you were in that room, which moment do you think changed the direction of everything? The letter? The filing? The nod? Leave it in the comments. I read every one. If this story stayed with you, please subscribe. A new story every week. And if someone you know has ever been told that something done without their knowledge was done for their benefit, share this with them. Sometimes the most important thing is knowing that the document exists and that it was written correctly and that someone is still reading it. Take care of yourselves. I'll see you next week.